Good day, everyone. I am very excited to share my views on the relevance of the core Hague Conventions in the regulation of digital commerce. My name is Anél Stegmann. I work as a legal advisor for one of the three largest licensed operators in Namibia. Namibia has the second largest sand dunes in the world, so it is only appropriate that the theme of my discussion is sandboxes. Let's jump right in. January 2021 saw Africa launch the world's largest free trade zone, the Africa Continental Free Trade Area. With its implementation, the continent is creating an entirely new development path according to the World Bank, underscoring the need for capacities to support the seamless cross-border movement of finance. Trade is becoming seamless, but regulation across borders remains static. Businesses looking to invest in Africa need to understand the policies and regulatory landscape on a country-by-country basis. Africa is incredibly diverse. A single approach will not work. I say this because, for example, in Nigeria, mobile money is regulated by banks, but in Kenya, it is overseen by the telcos. In Namibia, it is regulated by the central bank and by the Payments Association. In addition to the different bodies responsible for the sector, the countries also use different languages, business systems, and have access to vastly different forms of infrastructure. In 2018, the World Bank Group and the International Monetary Fund launched the Bali FinTech Agenda, which proposed a framework on high-level fintech issues that countries should consider in their domestic policy discussions. Findings from the report included three major themes, two being of most relevance to this discussion. Firstly, legal frameworks to address issues are widely missing, and secondly, the monitoring of entities and activities is still confined within conventional regulatory parameters. I pause to briefly consider the last finding in the report, which was the lack of critical infrastructure. In Africa, without the needed physical infrastructure, the regulation will not even be necessary. In addition to the need for infrastructure is the need for education to achieve digital literacy. This is, however, not part of the discussion today. Returning to the first problem of the lack of regulation, it is interesting to consider a report done by the law firm Cliff Decker Hofmeyr. They posed several questions to their managing partners specializing in fintech across Southern Africa. The answers were very similar to the questions. But to the question, does lack of regulation of fintech play a role in stunting development in your jurisdiction? The answer was a resounding yes from all the participating partners in South Africa, Kenya, Mauritius, Nigeria, Tanzania, and Zambia. There is a symbiotic relationship between technological revolutions, business practices, and changes in law. The result of the report shows that some technological innovation leads to the modification of business practices, which in turn results in changes in law. But the pace of these changes varies, and legal systems may need time to reflect on the implication of progressive technological changes and develop a consistent, predictable, and flexible response to the new challenges. To give an example of why a regulation lags behind innovation, we can consider Kenya. The regulators providing oversight in the fintech landscape include the Central Bank of Kenya, the Capital Markets Authority, the Communications Authority, the Competition Authority, and sometimes even the Insurance Regulatory Authority. That is 5 regulators. These regulators have recognized the need to react faster and appear to take a test and learn approach through the creation of a regulatory sandbox. A sandbox is a controlled, tech-friendly environment with reduced regulation to facilitate experimentation with new digital products and services. Once the development has been done in a sandbox environment, one has to add the regulations relating to the specific area of business in which they operate. and the environmental, social, and governance outcomes that are required of companies, whether physically established or not. At the same time that regulators are creating environments with less regulation to test ideas, a 2019 IMF report encourages African nations to introduce tougher regulations to minimize the risk of money laundering, terrorist financing, and cybersecurity breaches. This disconnect between encouraging stricter regulation while creating regulation-free pockets is caused by a lack of trust in the non-traditional banking and business sector created through fintech. Therefore, we will explore the need for the continued use of the Hague Principles and their relevance to modernize local and regional law. Because digital systems are not used as widely due to a lack of trust, I will use that neat segue and start with the Trusts Convention. According to the summary of the Convention, the trust is a unique legal institution originally developed in the common law tradition, where a person places assets under the control of a trustee in order to fulfill a predetermined purpose or for the benefit of a beneficiary. The Convention has managed to remain relevant today because the Convention does not define trusts in its text. Rather, it lists the characteristics of a trust and the type of legal relationships created by a trust. To ensure the continued relevance of the Trust Convention, one must analyze whether deviations from the traditional trust can and should be regulated by the Convention. I'm going to give an example of a very old deviation and a modern deviation from the idea of a trust. First, let's start with the old deviation. In South Africa, one of the most popular ways of saving money is through a stokvel scheme. The name stokvel originated from the term stokfeds, as the rotating cattle auctions of English settlers in the Eastern Cape during the 19th century were known. With a stokvel, small groups of people collectively agree to contribute to a shared savings pool. Members benefit from the collective scheme by being able to access larger sums of savings on a rotational basis than they would otherwise be able to accumulate individually. While it remains a largely informal practice, it is reported that there are almost 50 billion rands worth of savings contributed by over 11 million members. It has characteristics similar to a trust, as people are entrusted with the money and must manage and disperse it for the benefit of those contributing. A more modern example of a non-traditional trust is the Data Trust. Not too dissimilar in objective to the South African stokvel, the Data Trust is being explored and tested to provide collective and participatory means of governing data. The key premise of how such a trust functions is that it is a legally enforced governance structure wherein members pool their personal data and entrust a trustee who has a fiduciary responsibility to act in the best interest of the members in the trust to determine how this data is to be used and managed. Now, the beauty of the Hague Convention is that it is written broadly to traverse jurisdictions, language, business practices, and even developments such as the stokvel and data trust. In terms of the trust regulation, the Hague Convention remains valid and very handy for developing guidelines for the protection of the beneficiary of the trust, no matter the content of the trust. Now we wonder, how do the other two conventions fare in the digital era? There has been much greater development in terms of contracting and securities. The use of distributed ledger technology, more commonly known as blockchain, has led to the development of smart contracts and tokens. These innovations are expanding throughout numerous business activities in radically different ways, and some of them have raised a discussion on the need to adjust the underlying legal frameworks. Let's first consider contract law and smart contracts in terms of the principles on choice of law in international commercial contracts. Theoretically, a blockchain network can create an environment where participants can interact with each other and generate offers. Such offers can be accepted by the parties using a combination of public and private keys, which represent the identity of the parties, consent, and ultimately the meeting of the minds required for the formation of a contract. However, contract formation through a blockchain network, where parties can operate under a pseudonym or remain private, can result in failure to comply with legal requirements such as capacity. In Germany, the court stated that machines cannot make a valid declaration of intent or act as agents, as they lack legal capacity. Moreover, the governing law of the blockchain network, in case it exists, and the governing law selected by the parties will also have requirements relating to formation and capacity. With the question of formation, the concerns of authentication, performance, and enforcement also arise. Contract law needs some adjustments to adapt to new technological innovations. Rules need to be established to connect the actions of machines to legal or natural persons to provide legal certainty to automated contracting. Smart contracts need to be integrated into the general legal framework as special mechanisms for performance. This should include a legal definition of smart contracts, as well as special rules to recognize the authentication mechanisms embedded in blockchain and the resolution of disputes. Some countries still require contracts to be in writing, initialed, and be signed before witnesses. As with contract law, the issues of performance is pertinent. It is even more so in the securities world. So let's take a look at how the Securities Convention has fared against the test of time. Traditionally, both securities and negotiable instruments were tangible paper documents that incorporated rights. With the possibility of digitization of these documents, the law created the category of transferable records, which are electronic records that entitle the holder to exercise a right. Transferable records helped adapt the law to a new reality of paperless documents. The law of payments was transformed and adapted. Then it was again transformed by intermediation, and now it is once again being transformed by disintermediation. Through the use of tokens, parties can interact without the need for a broker. There are three classifications of tokens: security tokens, utility tokens, and payment tokens. Payment tokens are often referred to as cryptocurrencies. In this instance, we're going to look at security tokens. Security tokens can provide the same rights as traditional securities such as bonds and shares because they operate on rule sets that can be programmed into blockchain. The blockchain can ensure the integrity of the information included in it and the integrity of the chain of transfers. But the blockchain cannot guarantee the existence of an asset outside itself or the right to receive that asset. For instance, a token that gives its holder the right to receive a diamond of a certain quality cannot guarantee that the diamond exists in reality and cannot ensure that the holder of the token will receive the diamond when promised. So there must be a gateway with a physical reality. Liechtenstein has created a system where any asset or right can be tokenized under a system that relies on physical validators. They ensure the correspondence between the token and the physical reality. Security tokens can be integrated within securities law. If a token purports to grant the rights of a security, the issuer will need to follow all the requirements of the legal regime, starting with registration and prospectus requirements. Commercial law must be modernized to enable technological innovation to achieve its full potential, produce predictable results, and most importantly, mitigate risks. In any event, legal changes should be technology neutral to ensure flexibility and adaptability. In addition to following the guiding principles of the Hague Conventions, and where these conventions on their own are not sufficient, the regulator must consider the overall objective of the regulation. On the one hand, the regulatory regime can fulfill a guardian role, focusing on systemic risks and threats to the wider economy and protecting customers. On the other hand, the regulator can actively promote fintech through creating regulatory sandboxes to foster development of the digital economy. There is a risk that if the goal of the regulation is unclear, the new rules will simply attempt to retrofit the new technological developments into existing regulation. I propose a hybrid model. Regulators should use the Hague Conventions and existing in-country legislation, if any, and test the outcomes in a sandbox, removing restrictions to trade as the product or idea proves its worth to the digital economy. No matter the form of regulation or the type of technology employed, laws must always be certain, technology neutral, targeted, and effective across border. I'd like to conclude with a quote from the chairman of the Financial Conduct Authority, Mr. John Griffith Jones. He said, "We have come to realize that the more detailed regulation that we have, the greater the challenge of keeping it all current. Laws that were designed for the paperwork era do not necessarily work for the online one." I'd like to propose that we move into the sandbox era. Thank you.